is because it was the only way to have anyone testify about the allegations that were at issue. So I said it kind of plainly in the email last night, and I'll say it plainly again. I think that if we subpoena either of the children, we lose this case. Now, it's a risk. It's a substantial risk. If you have decided that you are ready, that you want to take that risk, I cannot tell you that I will not do it. But what I am telling you is that it is my strong recommendation that we do not bring either of the kids to court.
Okay, so I understand what you're saying, Erin, mm-hmm. And I guess my only comeback is the risk to me is the fact that if we don't bring those kids in there to one, establish that they've been told not to speak, they've been told that there will be consequences if they talk, that they've been told don't talk to daddy about certain things that go on in their house. Mm-hmm. That my kids have been threatened. They've been hit. Mm-hmm. My son has been hit multiple times. Mm-hmm. And what you guys see in the YouTube channel is just that's years ago, but it's still happening right now. And the sickening part about this is that these things were told to Angela Morehouse. Mm-hmm. This is all told to her. Mm-hmm. So I guess my question is, and I mean you too, Brett, if we don't have the kids in there to pretty much establish that what Angela Morehouse is going to try to do now is go into court and this was about me attacking Joe first. That's why my kids were taken away. Now it's going to be about me manipulating my children. Mm-hmm. So how do we say, hey, Your Honor, this isn't going to happen because I myself, Ramon Harris, I'm going to get a notarized letter saying that if these children talk to the judge, I have no problem giving up my parental rights that same day.
Well, that's going a little far, and you're not going to want to do that. And even if you did want to do that, it's a much longer process than just getting a notarized letter.
Yeah, Mr. Harris, that's a stunt that's not going to work. Now, we've talked about, and I don't think I've gotten a chance to tell Erin, so I want to get her up to speed right now about what Angela said in the last hearing.
Please do. Thank you.
Okay. Yep. So, because that, I think, can inform what we can do from here. And, again, the risk right now is if we called your children or subpoenaed them as witnesses for this hearing, the judge would not look on it kindly. We're many steps ahead of being able to do that in an effective way will actually allow your children to get protected, okay? But let me explain to Erin what happened, and then we can all put our heads together on what we can do.
Okay.
So Angela came to court, and she did a motion to quash the subpoenas based off of father not having leave of court to be able to ask for it. Mm-hmm. There was information I received from Mr. Harris that is completely reliable that showed that he did ask for leave of court, did inform Judge Barrett about it, and Judge Barrett kind of glossed over it. Mm-hmm. Okay? There's no note in the file from Judge Barrett saying that I give him leave of court to file for the protective order or anything else like that. So the substitute judge, her first name starts with an M, but she substitutes for Judge Barrett on a regular basis. She basically said, I'm going to agree with the guardian ad litem, but she asked Angela whether or not she had talked to the children about the allegations. Angela said she had. She then said, is there any basis to them? And she goes, I believe if they were called to testify, they would not be able to establish anything that would allow them to have a protective order, so there is no basis. And this is what she represented to the court. Okay? Mm-hmm. Now, she couched it, and Mr. Harris, you have to understand this. She couched this in terms of saying she didn't say there was never any abuse, there was never a hit, there was never any touching, anything else like that. Uh-huh. What she said is that specifically she had talked to the children and investigated. Investigated is the key word that she used. And that there wasn't a basis for a protective order, and their testimony wouldn't establish one that should issue. So if the children, in talking to you or your mom or any other family member or anyone else, say they talked to her and they told her they were hit and that they were scared or anything else like that, that directly contradicts a representation she made to a juvenile and district court judge.
Yes.
Okay? Mm-hmm. That can be the start of calling into question her role in the case and potentially having her replaced, removed, or whatever. But you have to understand, if she was cagey about the words she used in court. So it's not a slam dunk if your kid said, we talked to her. That's not an aha moment. She said she talked to them. If the kids say, we told her something bad happened, that's not an aha moment. We still don't have it, okay? If the kids tell you what they told the police officer, and you get that recorded, then we may be in a situation where if they told that to her and not some other version, and they're willing to say that on a recording, that they told Angela, not a police officer, but Angela, this is what happened, and she ignored it, then there may be a basis to come to court on a motion to remove her. Okay? But you have to understand, we can't fill in any gaps here. It has to be a Venn diagram that's a circle and completely overlapping. There can't be any room for error for this to work. You understand that?
Okay.
I'm listening, so I'm trying to understand right now. So we're going to go to court, and my kids are 10, and 8 years of age, right? We're going to go to court knowing that Angela Morehouse is going to pretty much go in and just continue to demolish my character as a father, continue to demolish my kids' words of what they said. And we're going to rely solely off of Erin saying, I'm a good dad. Is that it? That's what we're going to do? And I need to see my kids. That's what we're going to do?
No, that's not the sole factor that we're relying on. We're going to go through the custody factors. I mean, we went over them a lot in our preparation for the circuit court case, and we're not presenting the same evidence because we're looking at just kind of a different point. We're looking at a different point in time here as our starting point, and we're looking at a different form of relief. Like in circuit court, it was very much an all or nothing proposition. This is not that. There's a lot of gray areas where we can do better than what you have.
Visitation.
Yeah, visitation.
So, yeah, Mr. Harris, there's a big difference between the two. The one is basically who gets to control legal decisions regarding the children. The other one is what's in the best interest of the children and who they get to see so they develop and grow properly. Okay? And we're not saying that the first decision, the custody decision, can never be revisited. But you have to understand that, again, going off premature here will mean that you are going to be less able to raise the kind of good case you want to be able to raise later if you have an opportunity to raise it. So if Erin does something like in her judgment that would backfire, like trying to call the kids at this stage, not saying she's never going to do it, but what she is saying to you, and I agree with her here, if you do it right now, you're not going to get the result you want. I can almost guarantee that based on my experience, and I'm not even a family law attorney. But I know enough of them, and I've seen enough of this to know that at this stage, you have to go in not with, I think when I told you this analogy before, Mr. Harris, you can't lead with jabs. It has to be a haymaker. So until you're ready to make that swing, and we're not ready to make that swing yet because we don't have what we need yet, we have to save that punch.
Okay,
I guess my only thing here is, if I may, so my son is 10 years old. He's asking, I'm his dad. When are we going to move back? Dad, I'm ready to leave. I'm tired. My son talks about killing animals. My son talks about killing tyreecarr. So is that going to be asked to me as to like the factor of like? So that's what I'm kind of like wondering. Like, what exactly is going on?
Okay, well, this is not that case. Like, you know, like I said, this is not a custody case. This is not with whom the children reside primarily. This is not who gets to make the decisions for them. This is just talking about time sharing. And like I said,
we can't bring up nothing what these kids are going through right now, what they're experiencing.
No, we absolutely can bring it up. I'm just saying that when it comes to your custodial time with the children, a judge can give you more and is more likely to give you more if we do not subpoena them at this time. Okay. Because, again, we're just talking about custodial time. And with the current circumstances, we're not, I don't think that a 50-50 schedule at this time is realistic anyway. Just given that, these are school-aged children, they need to live near where they go to school. You do not live in that school district.